California, certainly.
That's one of the reasons why I tell clients not to talk to social workers unless, we're on the phone or present with them. This happened to me on a case in Northern California a couple of weeks ago. I went up there knowing that we were going to have a trial, a contested disposition hearing. And the county counsel comes to me and tells me, didn't you know that your client is not going to have decided not to have a trial and just agree to suitable placement of the child with relatives and will come back in 6 months and give her family reunification services? And I said, no, I didn't know that. So I went outside and talked to my client. He said, when did you decide this? Oh, well, the social worker was talking to me, blah, blah, blah. And I said, I thought we had an agreement. You wouldn't talk to the social worker without me, because the disposition hearing is, the one-of-a-kind hearing that offers the ultimate protection to a client. They have to prove by clear and convincing evidence that the client is a substantial danger to the child, and there's no less restrictive alternatives. You don't see that anywhere before or after in the code. And in this case, in my humble opinion, they couldn't prove by clear and convincing evidence that my client was a danger to the child. They couldn't prove that there weren't any less restrictive alternatives. But my client had been convinced by the social worker to not have a trial. And of course, who am I? I'm just the lawyer. If that's what my client decides, that's what she decides. I think she got bad advice from the social worker. And we'll see in another 6 months if they come back and they're willing to give her back the child. We'll see. But that typically doesn't happen. Hey, Jennifer,
you're so correct about the stage of proceedings. Everything else in this area of law, although you're dealing with the fundamental right to parent your child and the child's corollary right to be raised by a parent, the burdens of proof are substantially less than they are in a criminal case. 51% is the burden at the jurisdiction hearing, but to detain, it looks like it's bad. It's probable cause. So at disposition, I agree. The clear and convincing standard is, while it's not beyond a reasonable doubt, I think it's been described as 85% or, quote, no reasonable mind can differ, unquote, which taken literally, that is a very high standard. But oftentimes, attorneys don't push dispositions as hard as they should, and social workers do take advantage of that.
Yes,
Absolutely.
They do.
Absolutely. And you'd like to think that they're public servants and out there for the public good, but of course,
not all the
there
time.
are exceptions.
Yeah,
there are exceptions. There are good social workers out there,
mm-hmm.
and I certainly don't mean to slight those, but it seems that it's tough to get good advice from social workers.
Right. Hey, Jennifer, we have to take another break right now.
Yep.
We'll be back. We'll take more calls, listen to more questions and stories. This is The Secret, How to Fight Child Protective Services and Win.
You're listening to How to Fight.